thinking of ADR, when you are thinking of mediation, you must take on board the stakeholders. The main stakeholders are the lawyers. As far as I have gone for the ADR mechanism, I have discussed the same with bar members in Balochistan. We have taken on board the lawyers in the first instance so that they may be able to digest this system. Otherwise, plainly thinking, the lawyers will be deprived of litigation. They will be deprived of the brief. If a judge has 20 cases and in 10 cases parties consent for alternate dispute resolution, the lawyer is losing the 10 cases and he will get scared that my practice is going to be finished. So please open a window for the lawyers, and government should think that the lawyers of integrity and good reputation should be taken as mediators. They should be well compensated so that they may have some adjustment of the financial losses which they will suffer in case the ADR mechanism is adopted with success. Presently, there is some scaredness. What I did in Balochistan, Supreme Court took the initiative that alternate dispute mechanism should be adopted in all the provinces. In the first instance, I called the members of the Bar Council and I asked them to constitute a delegate of lawyers from different age groups, and I sent them to 3 provinces for a study tour. Go and study KPK, go and study Lahore High Court, go and study Sindh High Court, what they have done in respect of ADR mechanism. And I availed the cooperation of the lawyers in the first instance. And resultantly, we started ADR system in Balochistan. Let me give you a resume. The ADR mechanism in Balochistan province is supported by UNDP. We are having a project in UNDP in Balochistan as Amno Insaf program, and they are financially supporting us. And we are adopting the court annexed ADR. Presently, we are adopting the court annexed ADR mechanism in the province, and we have also made legislation in this behalf. The officers, the legal officers, including my judges of the High Court and lawyers, they planned tours in different provinces in the year 2021, and whereafter we were able to promulgate Balochistan Alternate Dispute Resolution Act 2022. After promulgation of this act in 2022, we have established 2 mediation centers by posting 2 serving judges as mediators, and recently they have decided 8 cases through mediation. And we are expecting that number of family cases will be referring to these mediation courts. Apart from the commercial disputes, I have the vision to involve the criminal cases as well, because the cases involving human injuries under Qisas and Diyat ordinance, now they are part and parcel of PPC. Even in murder cases, compounding of offences is permissible by the legal heirs of the deceased, as well as in case of injured, it is permissible with the consent of the injured. So I am anticipating that in the days to come, we will be having criminal cases as well to these mediation centers for effecting compromise and compounding of the offences. Similarly, I foresee family matters as well as the matters of inheritance. As I say, there are 2 parties to the litigation. Delay is suiting to the one party, and the other party is having anxiety of quick disposal. Similar is in commercial disputes. In commercial disputes as well, one party is anxious for early disposal and the other party is having delaying tactics. So we have to regulate the proceedings, and we the regulators are heavily burdened to shoulder the responsibility. Today, in the first session, words were said about execution of degrees, misery of litigation. My view is that degree is not enough. Either you adopt any mode. You may have normal litigation under CPC, or you may have any mechanism, alternate dispute resolution or arbitration. End of the day, you can't avoid judges, because whatever the verdict is, it has to be made rule of the court, and that is by the judge, by the judgment. So again, a judge is there. So we have to be responsible, we have to be sensitive. Otherwise, no system will work. Every system has complications. I can tell you a number of stories in Arbitration Act of 1940. There are certain provisions we will be dilating upon tomorrow's session. I have seen the issue of court fee on the memo of appeal in arbitration matter went up to the Honorable Supreme Court. And it took years. So what was the use of that act? Then I can quote you examples with regard to the appellate jurisdiction in arbitration proceedings. Specific provisions have been provided, specific orders have been mentioned which are appealable under Arbitration Act 1940. But we opened avenues in revisional jurisdiction for redressal of grievance to attend certain point. And on an interim order, a revisional matter went up to Honorable Supreme Court and remained pending for years. So we can't say that every system will work. Yes, it will work if we evolve an efficient mechanism. Unless an efficient mechanism is not involved, no system will work. In the second session, it was opted that chartering the course of mediation in Pakistan. Should Pakistan be a signatory to the Singapore Mediation Convention? Yes, Pakistan should be a signatory. Why we are delayed? Why it is so late? Why the government is sleeping? I don't know. We are all talking here today, and end talk is about legislation. I am feeling a lacuna in this auditorium, in this workshop, in this seminar today. With due respect to Barrister Shiraz, I am not seeing any legislator in this auditorium. Why? We are discussing all the problems and the solution lies in legislation, but we are not having legislators here. We, the judges, cannot make the law. You, the lawyers, cannot make the law. We can interpret the law. We can apply the law. We can struck down a law which is in contradiction to the fundamental rights as guaranteed in the Constitution, but we cannot make the law. So who has to make the law? It is the legislator, but they don't have the priority. 75 years have passed. Today we are talking about the judicial system, and we all are convinced that it needs robust reforms. There is no second thought. I will not say that system is failed. No. But it has to be made more efficient. I am judge of the High Court. I have practiced law. I will never say that our judicial system has failed. No, it has not failed, but it needs reforms. It needs reforms in all tiers. Justice Asif Sidkosa was with me in a meeting, and before taking oath, he shared with me in Quetta. He came in a bench and said, I am of the view that we should less the tiers of litigation. I said, sir, how? What is the idea? And my lord said, I am of the view that in civil court, we should have only one district court. No civil judge, no senior civil judge, no additional judge, only one district judge, dealing with civil cases as well as the criminal cases. And one appeal to the High Court and second to the Supreme Court. I want to less one tier. I said it is a very good idea and you can reform. But when he took oath, he failed to reform. I went to Iran for a study tour. In Iran, what was surprising for me, after judgment of the trial court, when an appeal is filed, the system in Iran has left it to the wisdom of the appellate judge to go through the appeal in chambers, to go through the record, and if he is of the view that the judgment of the lower court is not suffering from any error or illegality, he may uphold the same in chamber and dismiss the appeal in chamber without giving any right of audience to the parties or counsel. And if he is of the view that judgment is suffering from any legal infirmity or lacuna, he may order to fix in court and call the parties or their advocate for arguments. It was very surprising for me. I shared this idea with Honorable Justice Guzar Sahab when he had taken oath as Chief Justice of Pakistan. I was having a Federal Review Board meeting in Karachi, and Justice Guzar Sahab was in Karachi heading a bench. So Justice Manzoor Malik was with me, and he said कि चलें जज साहब के साथ चाय पीते हैं, उनको मुबारकबाद भी देते हैं. We went to the chamber of Justice Guzar, and I asked permission from my Lord, the then Chief Justice of Pakistan, to say few words and make few suggestions. And he permitted me कि कहिए बात कहिए. My Lord, I said, sir, I have seen this Iran, and I suggest that Supreme Court is going to change the rules. A committee has been constituted to revisit the Supreme Court rules, and I suggest, my Lord, before you that the petition for leave to appeal should not be fixed in court before the two judges. It should be marked to a judge of the Supreme Court in chambers, and it should be left to the wisdom of the judge of the Supreme Court to go through the record of the lower courts, to go through the judgment of the High Court, and system should leave it to the wisdom of the judge of the Supreme Court, because it is the court of law, not the court of fact. If a judge of the Supreme Court sitting in chamber after going through the record is of the view that the judgment is proper, list has been decided properly, he may refuse the leave in chamber. And if he is of the view that there is a legal infirmity, there is a lacuna which needs to be rectified, he may grant leave to appeal in chamber, and in this manner, as per my estimation, we will get rid of 35,000 cases in Supreme Court. But he said it is a good suggestion and we will discuss in the meeting, but things did not mature. So we have to take the things, we have to carry the things, and we have to, actually we have not passed the process of evolution despite passage of 75 years. They have tailored the system. UK was having the same system, but they have tailored the same. We have failed to tailor the same. So we are facing, even today we are facing. Legislatures, they don't have the priority to legislate for the common man. Yes, they do legislate for themselves. They have done with retrospective effects, but not for the common man. They are not ready to legislate for the common man. We are talking here today for the common man. So we should think, but my humble submission is to Barrister Shiraz, next time in the session you must invite the legislators. Secretary Parliamentary Affairs should be here. Minister Law should be here. Parliamentary committee members should be here. Members from Senate should be here. Members from National Assembly should be here. So that we may sensitize the issue. We may make them realize why the people of Pakistan are suffering, because they are not evolving the system. They are not bringing the required legislation. I am taking your time. I am sorry. I am engaging you in the late evening, and the credit goes to Mr. Shiraz. In the third panel, the construction disputes in Pakistan and how should Pakistan deal with CPEC disputes. Don't take me biased. I am a Pakistani citizen performing my duty in Balochistan. The question to the House is why we are discussing CPEC issues while sitting in Lahore PC. Why not Gwadar PC? Unless and until you put your feet on the ground, you will not be able to realize the ground realities. You will not be able to realize the real problems. The mainstream of CPEC is Gwadar. I am very happy to travel on CPEC roads in Punjab. I am really happy to travel on CPEC roads in Sindh. I am really happy to travel on CPEC roads in KPK. I am not aggrieved, absolutely not. But the question is, it is the question to the policy makers. We, the judges, cannot interfere in policy. Policy decisions cannot be interfered under Article 199 of the Constitution. So I am putting a question to the policy makers. Why the first CPEC road was not started from Gwadar? Why? Which is the main stream of CPEC. You may enjoy the road in your sister provinces. If you don't have a CPEC road in Balochistan or Gwadar, how will you transport the commodities from Gwadar deep seaport to South Asian countries, to other cities of Pakistan? So, wrong policy decisions have given rise to insurgency in Balochistan, which is combated by the law enforcement agencies. We have provided space to our enemies to instigate the miscreants. All the citizens in Balochistan are very patriotic. The people of Makran are very patriotic. They are very educated. Just you come and you have interaction for yourself. You will find PhD Baloch ladies, you will find PhD Baloch boys, you will find PhD Baloch boys in Pashtun areas, far-flung Pashtun areas, having PhD from Germany, having PhD from Thailand. You will be confronted with female Baloch girls who were having education and matriculation from far-flung villages and going to PhDs to Thailand, having meritorious results. I had been on the board of university for selection, and I am always surprised. The Baloch boys and girls, highly qualified Baloch boys and girls, highly qualified Pashtun boys and girls are coming for interview, for appointment as lecturers, for appointment as associate professors. And whenever I came from those meetings from universities, I share with my brother judges that I am seeing a greater, brighter Balochistan. I don't know who the insurgents are. I don't know them. And I tell you, we are with the concept of justice at the door. And we, with the concept of justice at the door, have established courts in far-flung areas of Balochistan, where my judges in the subordinate judiciary are performing their duties without any fear. We have two circuit benches, one at Sibi, which is at a distance of 2.5 kilometers from Quetta, and we are having a circuit bench at Turbat instead of Gwadar. Again, an option by the legislators. And for Turbat, we have to travel 10 hours by road from Quetta, or we have to take flight to Karachi, a night stay at Karachi, and then to Turbat. And Turbat and Gwadar are at a distance of 2 hours by road only. I have developed infrastructure in Gwadar. We have 4 terminal buildings in Gwadar. 2 terminal buildings are housed by district and session courts, and 2 terminal buildings are lying vacant now, awaiting international forums to come. But my government is sleeping. Still, 13 years have passed for CPEC. My bureaucrats are sleeping. My government is sleeping. Not a single endeavor has been made to bring international forums for dispute resolution to Gwadar, to Pakistan. My colleagues have named the institutions in Malaysia, in Dubai. They have done their homework, so investors are there. We have not yet done our homework, and we are dreaming that investors will come. How the investor will come? They are very sensitive. They are going to see what the judicial system is. So we are to reform, either we have to, or we are going to make these words and go home happily, having dinners, having chatting, having clapping, okay, fine, everything fine, very good function. But what is the practical outcome? Nothing. So we should be practical, at least I am practical. I travel by road as a Chief Justice deliberately in far-flung areas of Balochistan to convey message to the masses that there is no no-go area in Balochistan. And if a Chief Justice can travel by road with all threats, then anybody can come. So I request the House, I request the administrators, I request all the persons present in this auditorium to have a next session in PC Gwadar. I will facilitate. Let you have interaction with local persons. The real CPEC starts from Balochistan. And if you fail in Balochistan, you fail in CPEC, I tell you. In third panel, Madam Virginia Claudita said that, asked the question whether the judges of Pakistan have the capacity to decide the issues of CPEC contracts. Madam, don't undermine the judges of Pakistan. We all have the capacity and ability to decide any kind of matter, any kind of list which is brought before us. I have dealt with procurement cases in respect of 2 CPEC road projects which are just now started in Balochistan. The federal funded projects are governed by Pakistan Procurement Rules 2004 and the provincial procurement processes are governed by Balochistan Public Procurement Rules 2014. My brother Judge Asim Saab have said few words about bid security, performance security and security for mobilization advance. The Pakistan Engineering Council has laid down standard bidding documents which are mandatory and which have been also approved by the ECNIC. In those bidding documents, the bid security for 28 days has been mentioned to be furnished by the interested bidder in the shape of bank guarantee, call deposit or AA rating insurance company. But to avoid healthy competition in the relevant BEPRA rules, the AA rating insurance companies have been excluded to support the monopolist contractors having very sound financial positions. I have authored judgments to the government of Balochistan with instructions to amend the rules and to allow wide competition under the rules. We can deal with any case, we can deal with any matter subject to assistance rendered by the lawyers. So don't undermine the judges of the Pakistan. Mushalam said few words about IT solutions. Yes, sir, I do agree. I was lucky enough to be with my Lord in Automation Committee of Supreme Court and we were conscious that there must be trainings. I was in America and I spent one day in Washington Academy where I was surprised. The judges of the High Court there, they have federal courts, were having a training of 6 months. Can we have training of High Court judges in Pakistan? Now we are akle kul. We mind if a lawyer come to the court कि सर लॉ ये कहता है और कानून तो अच्छा आप हमें कानून सिखाएंगे अब. So we are not absolute. We are not absolute. I, despite practicing law for 22 years and despite being a judge for 12 years, I am still a student of law. I am still eager to learn. So we are here to learn. I request Honorable Chief Justice, I will also request him personally in the next meeting that we should have a judicial academy for training of the judges of the High Court of, because we are not utilizing the IT technology in its true prospect. I have some judges who don't even know how to feed a number in their mobile. They have not even opened the laptop. They can't function the computer. So we, the judges, have to learn the information technology. In America, they said, yes, we were having the same problem. Most of our judges were in old age and they were absolutely unaware of the information technology. We made it mandatory for them to be trained in academies, and now we are having paperless litigation. We are having paperless courts. I also dream for the same. But for realizing that dream, we need training. Our judges need training. Our lawyers need training. So we all need trainings. Asim Hafiz also said few words about change of culture. I do agree. Reform is not only required in the judicial system, but reform is also required in the society. We have to educate the litigant as well. A litigant must come to the court with whole truth. A complainant in a murder case must come to the thana, to the police station for lodging FIR with whole truth, without any fabrication. If we achieve this object, frivolous litigation will be lessened. My task, I say, in a murder case, I am always in trouble in a murder case because I am confronted with false evidence, with false witnesses, and I have to search truth from the false evidence. Almighty blesses, Almighty guides. That's another phenomena for a judge. Time. I'm sorry, I'm coming from Quetta far away. I will take my time. I'm sorry. So we have to reform the society as well, and I would urge the litigant to come to the court with whole truth. In the end, I am conceding to your request because I am a judge, I have to honor your request. So in the end, I agree, yes, we have to make robust reforms, yes. Corruption has to be eradicated from the government departments. The corruption, nepotism, and bad governance in government departments has burdened the High Courts with writ petitions. If this aspect is controlled, our writ petition will be lessened. It is high time for us to reform in the judicial system at all levels. Society also needs reforms. Judges and lawyers need trainings. Sensitivity and responsibility of lawyers, arbitrators, judges and mediators is need of the time. And we have to adopt different strategies for clearing the backlog. And in the end, I will say thanks for patient hearing. Thank you very much.
I'm extremely grateful, Your Lordship, Mr. Naeem Akhtar Rahman, for sharing us the words of wisdom. I will now request the pleasure of having Honorable Mr. Justice Tasadduk Hussain Jilani to please share a few words with us. Thank you.
Honorable Chief Justice Balochistan, Honorable Chief Justice Lahore High Court, judges of the provincial high courts, ladies and gentlemen, I must congratulate Barrister Shiraz for organizing such a conference in Lahore. Perhaps it's for the first time that such a conference has been held and organized by a lawyer's body. I was not scheduled to make remarks and make a speech this evening, but Barrister Shiraz asked me to sum up and briefly comment, And since I have to go somewhere for a family engagement, I'll just briefly, first of all, say that no system is perfect, no country is perfect so far as administration of justice is concerned. But having listened to the speeches and presentations today, I am delighted to observe that we have come a long way. In arbitration particularly, we gave a judgment in Habbo's case where arbitration was scuttled on the principle of public policy. But then today we find tremendous interest in arbitration, and the last judgment in the realm of arbitration is that of the Orient Power case, the judgment authored by Justice Bashir Alam. In that case, I appeared as a Pakistan law expert before the London Court of Arbitration, and I was the expert judge, and I was subjected to cross-examination for the first time in my life, but then the award came in favor of what I said and in favor of the party. The second thing I noted today was that tremendous use of technology in the administration of justice. In particular, I find the KPK courts, KPK High Court using technology in the administration of justice, and thereby they have expedited the disposal of cases. The Lahore High Court has also been very dynamic. I particularly mention the judgments of Justice Jawad Hassan, who is indeed a catalyst in this field. And when I talk of the progress made in the use of internet and video link, I must mention a recent judgment of Justice Mansoor Ali Shah, wherein he held that the statement of a witness can be recorded even if the witness is abroad. So that was a very dynamic approach, and in fact it was a very progressive interpretation of Civil Procedure Code. Perhaps a time has come for us to have an international arbitration center on the pattern of DIFC, on the pattern of Singapore, and on the pattern of Qatar Dispute Resolution Center. I had the pleasure of deciding an international arbitration case as member of a tribunal in DIFC, and I had the pleasure of sitting with the Chief Justice of the Qatar Disputes Resolution Center. So I think it's time that we should make further progress, and we should open up an international commercial court having a credibility of the kind that DIFC has. For that, we have to make appropriate legislation. Without that, it can't be. With these remarks, I'll take your leave, but it has been a very educative day for me. Thank you very much.
Thank you, Honorable Mr. Justice Kusanjalani. Can I request the pleasure of the company of our Lordship, Mr. Muhammad Amir Bhatti, Honorable Chief Justice, Lahore High Court.
Bismillahirrahmanirrahim. Honorable former Chief Justice, Supreme Court, former judges of the Honorable Supreme Court, Honorable Chief Justice, Balochistan High Court, Honorable fellow judges, distinguished guests, ladies and gentlemen, Assalamu alaikum. A very good evening. It is a privilege to address you all today on the occasion of Pakistan International Disputes Weekend 2023 with such a prestigious audience. I welcome all the speakers and participants, especially those who flew in from different parts of the world to attend this event. I express my gratitude to the organizers of this forum for arranging this event and uniting the distinguished luminaries of the legal and associated fields under one roof. The panel discussion that took place throughout the day were quite impactful and will play a keynote in aligning our vision for the legal landscape for Pakistan's future. I truly hope our speakers were able to transfer some fraction of their knowledge to the audience. The insights and expertise offered by the extreme speakers all culminate and focus on the essential issue that gravely affects us as a society, the state of the legal landscape in our country. I stand before you all today with a deep sense of responsibility that is entrusted upon each member of the judiciary. The responsibility of the judiciary of Pakistan in carrying the weight of efficient and expeditious resolution of disputes and upholding access to justice for the largest province of the country with a population of more than 110 million based in 42 districts. As we all know, the Constitution of Islamic Republic of Pakistan promises inexpensive and expeditious justice, and it is the duty of the High Court to deliver the constitutional promise and protect the fundamental rights of every citizen granted through the Constitution. Speedy and efficacious justice is one of them. We all can agree on the fact that the influx of cases in Pakistan supersedes the rate of their resolution. Our courts are flooded with cases, and the demand for justice continues to increase every day. It is not humanly possible for approximately 4,000 judges around Pakistan who work even extended hours to resolve the millions of backlog of cases pending in Pakistan. And as a result, the judge-to-case ratio becomes imbalanced on account of limited resources. Pakistan is traditionally litigious society with biggest challenge of the huge amount of frivolous litigation that comes to the courts. We will be amazed to know that civil deals with approximately 200 and 250 cases per day where he is expected to issue notices, stay orders, record evidence, issue short orders, conduct trials, as well as issue judgments. In my humble opinion, the district judiciary exceeds capacity in terms of its performance, and that is truly commendable and should be appreciated. I do not claim that everything is perfect. All I want to bring before this audience is that my judiciary is trying its level best to deliver expeditious and efficient disposal of cases. Any further change is dynamic and requires the active input of the state as well as every citizen to commence change on a personalized micro level. With highly limited resources and with the everyday addition of population, there are a number of changes that require immediate attention, and we at the Lahore High Court are working actively with a number of proposals under consideration that may help in speedy and efficacious resolution of cases. However, we must all recognize that judicial system cannot function in isolation of achieving the level of efficiency we desire. The responsibility for the provision of resources and framework that nurses a supportive environment for efficacious and speedy dispute resolutions befalls the state primarily. The state is required to take concrete steps to facilitate the dispensation of speedy justice, including the provisions of necessary infrastructure and courtrooms, assignment of appropriate resources, deployment of more personnel, as well as enacting the relevant laws that may serve the purpose. The duty of the judiciary is to ensure the maximization of these facilities and utilize them skillfully to attain speedy and efficacious justice. Contrary to popular belief, the issue of delay justice is not limited to Pakistan only, as even the global best practices to bear the burden of expensive litigation and delay the worth of years when it comes to litigation. Despite court system performing at optimal capacity, developed jurisdictions such as the United Kingdom do face a disparity when it comes to their system of litigation. To supplement the delay and make it up for expensive litigation, global best practices are slowly moving away from the traditional court system to the alternatives. In fact, our neighboring countries have also begun reaping benefits from this alternative approach and have advanced their system of resolve. We understand and acknowledge that it is about due time for Pakistan to follow suit and begin incorporating alternative methods of dispute resolution in its existing framework. On its own initiative, the Lahore High Court has cognizant of incorporating procedure within the existing judicial framework to bring about efficiency in the institution and disposal of cases. The Lahore High Court introduced ADR as a mandatory exercise in civil sources by adding Order 9A and B notifying it on 15th August 2018. The Lahore High Court introduced admin courts as a result of amendments to the Civil Procedure Code. The idea of admin courts was to segregate the workload of the trial court, and the introduction of admin courts paved the pathway for the introduction of commercial courts. Although the efficiency of admin courts is yet to reach its desired potential, however, the initiative of segregation and sharing of workload has been effective in unloading the burden of trial court. The landmark initiatives of the establishment of commercial courts took place with the untiring efforts of my learned brothers, Mr. Justice Shahid Kareem and Mr. Justice Jawad Hassan. The culmination of their efforts was the Punjab Commercial Courts Ordinance 2021. The ordinance provides for a legal regime for the whole of Punjab for early resolution of commercial disputes and expeditious disposal of commercial litigation of specified value. Although the ordinance has lapsed, we are still committed to the continuation of this project. I have been actively involved in the redrafting of the Commercial Courts Act, which has been finalized, but unfortunately due to dissolution of the Punjab Assembly, the same is pending approval. I am hopeful that whichever new government will be formed, the Commercial Courts Act will be enacted by the Punjab Assembly. Ladies and gentlemen, as the Chief Justice of the Lahore High Court, I have made myself committed to incorporating the necessary changes. In all good faith, I have actively participated in drafting the amended Punjab ADR Act 2019, amended 2023. Back in 2021, when I took oath as a Chief Justice, being an administrative head, I established a Directorate of Judicial and Case Management and delegated the responsibility to devise a plan for rational fixation and speedy disposal of cases so that the backlog of cases could be settled. Along with these responsibilities, this directorate was empowered to monitor the activities of judicial and case completion wings of this institution. This step has enabled our case management system to align itself with the rest of the world by incorporating the digitalization into its system. The introduction of a case management system in Pakistan has been successful in periodically smoothing out the archives of abundant case law. This move has transitioned the layout and traditional setup of case management towards a more advanced setup which saves time and cost. In consequence to this fixation policy, we have witnessed a significant decrease in the disposal of the cases and significant reduction of pendency of the cases. It is pertinent to mention here that during this time period, 182,770 cases were decided, while the institution of cases were 168,560. So, considering the institution of the cases and previous pendency of the backlog of the cases is reduced by 14,522 2. Therefore, the pendency of the cases in Lahore High Court, Lahore, is 1,79,192. A more recent initiative to create a faster and more reliable process undertaken by Lahore High Court is Case Flow Management System. Case Flow Management System is an automated system that allows cases to be processed under a no adjournment culture. These automation efforts will improve data management and allow better accessibility of information. Case flow management system has recently gone into a live testing phase, already having the distinction of being the first High Court of Pakistan to develop its mobile app. The Lahore High Court is now working to introduce the concept of automated courts, starting with a pilot project on e-filing of cases under the same system. This will help the court become a paper-free institution, keeping in line with our commitment towards combating climate change. Alongside reduction in paper printing and storage costs, transitioning to online system will reduce the risk of documents being misplaced, damaged, or misfiled. Moreover, online digital files will be easily searchable and can be accessed as well as shared remotely. Here I must recognize and appreciate the efforts of my brother Justice Sujat Ali Khan regarding the establishment of the case flow management system. We are also in process of restructuring the website of Lahore High Court to increase transparency for all stakeholders, especially those who are hesitant to visit offices. The website of the Lahore High Court contains all the information with respect to judicial officers, beginning with civil court judge, class 3 to district judge in Punjab. It will keep the stakeholders aware of availability and composition of the bench well before time. Furthermore, it will also contain the latest judgment approved for reporting and articles for law students to create a robust and informed legal community. Ladies and gentlemen, the Lahore High Court is also receptive to foreign arbitral awards which are absolutely implemented in letter and spirit. The then Honorable Chief Justice of the Lahore High Court, Honorable Mr. Justice Mansoor Ali Shah, now the Judge of the Honorable Supreme Court, came up with a revolutionary approach to establish alternative dispute resolution ADR centers in all 36 districts of Punjab, with 72 dedicated judges to help parties achieve an amicable resolution to their disputes to refer a matter of ADR center. The judges in these centers were trained by the Punjab Judicial Academy to help parties reach a settlement through mediation, and 45 to 50% success rate was recorded at that time. I am of the firm belief that no effort for judicial reform can succeed without the positive cooperation of the bar. The bar has played a crucial role in promoting ADR in many countries, and we hope members of bar in Pakistan can extend same support to us as well. Thank you. courts are the courts are interested and looked upon as being able to offer the most effective, responsive and appropriate methods for resolving disputes. However, other methods of dispute resolutions are based on the understanding that adjudication can be supplemented by the incorporation of additional methods to resolve disputes. As disputes differ widely in nature, courts should support alternatives to the traditional resolution path. It is known that ADR does not work in isolation, but rather works in conjunction with court system. I'm pleased to learn that the Chartered Institute of Arbitrators, Pakistan branch arranged a global authorized certified mediation training in collaboration with the Islamabad High Court for a cohort of 50 legal practitioners. Mediators who pass the examination on globally certified standards are now enlisted with the Islamabad High Court as the first set of neutrals for Pakistan. I hope to include the system of enlisting neutrals in the Lahore High Court as well through the training of legal practitioners in Lahore. It allows our legal practitioners to develop an additional skill set which aids them in the expeditious resolution of disputes in addition to their traditional approach to resolution. Ladies and gentlemen, litigants must be encouraged to preempt disputes and put in place mechanism of dispute audience and settle disputes through other methods of dispute resolution wherever possible to avoid unnecessary litigation. Not just individual citizens, but it is also imperative that the government and the legislature recognize the importance of judicial system and try to equip the judicial system with resources and support they need. With the input of different individuals and executive organs, the possibility of a more just and equitable society becomes more eminent. Ladies and gentlemen, at the end of the day, our aim as representatives of the judicial system is to ensure that the end user, the ordinary citizen, is able to swiftly resolve his disputes. A balanced, impartial, expeditious and cost-effective dispute resolution procedure is fundamental to creating a more confident consumer and user environment. In fact, the Constitution of Pakistan places particular emphasis on upholding the constitutional rights of citizens. And to reach this end, Pakistan International Dispute Weekend 2023 is of particular importance as it motivates us to simplify the current legal landscape to ultimately benefit the most affected. Pakistan International Dispute Weekend 2023 is promising in terms of creating awareness and opening a portal towards a new dimension in Pakistan's litigation landscape. I'm honored to be a part of the upcoming change, which I'm sure will lead a better and brighter future for Pakistan. It was lovely speaking on this forum. Thank you very much.
I'm extremely grateful, Your Lordship. Honorable Mr. Justice Mohammad Amir Bhatti, Chief Justice Lahore High Court, Lahore. Honorable Mr. Justice Naeem Akhtar Afghan, Chief Justice Balochistan High Court, esteemed judges of the Lahore High Court, Sindh High Court, Peshawar High Court, Islamabad High Court, distinguished guests and esteemed speakers. As we approach the end of the day, I would like to take a moment to thank all of those who made today possible and seamless. I am extremely grateful to you for all your support. I extend my gratitude to our esteemed judges who joined us from different parts of Pakistan and making this conference a symbol of national unity. And I thank my fellow practitioners who flew in from different parts of the world. This would have not been possible without your kind participation. I thank the moderators of the day in ensuring that their panel discussions were executed smoothly and helped audience in garnering knowledge and perspective. Join us tomorrow to fully avail the benefits of PITW. I look forward to welcoming you all tomorrow as well. Till tomorrow, farewells and goodbye. Thank you all.